Hello guys, and welcome to another episode of my lecture. Today we'll be talking about the business of the company. When we read the provisions of section 87.3, it says that except as otherwise provided by the articles, the business of the company shall be managed by the board of directors except where the act or the articles are said otherwise. Now, the question that we need to ask is the business of the company. What to be regarded as the business of the company? I need us to go to section 868 of the CAMA. That is the interpretation section. And what does section 868 define business to be? It says that business includes any trade, industry, and profession and any occupation carried on for profit. You see, when it comes to interpreting certain things, just the same way the interpretation section could not define to us who a member of the company is to be in the general meeting, that's members in general meeting, it still has the same flaw when it comes to what the business of the company should be. However, when we are talking about business, although the act tells us that, profession, occupation that is carried out for profit, so anything that is profit oriented in a company is the business of the company. So when they said that the business of the company shall be managed by the board of directors, they did not say the affairs of the company, that is the running of the company. They said this one that has to do with profits. You know that in a company we have different departments. There is the marketing department, there is the technical department, this department, that department. So any department that has to do with the company's business would therefore be such that is, tailored towards the profit of the company. That's basically what section 868's definition of business is telling us. However, when we juxtapose this with provisions of other countries, for example, the Australian Act on companies, you would see that according to the Australian Act, business and affairs were said to be the same thing. Do you understand that? When you are talking about affairs, we are talking about how a company is run day to day. That's basically the affairs of the company. How do you run the company? That's the affairs. So according to the Australian Act, that's section 53A of the Australian Act. It tells us that the business of the company and the affairs of the company are the same thing. But when we go to section 2 of the Canadian Companies Act, it will tell you that when you are talking about the business of the company, it is totally different from the affairs of the company. You will see that these countries, they know what they are doing. In their CAMA would explain things to you. Okay, if they've said that the business and the affairs are two different things, it means when the provision says that the business shall be run by the board of directors, they do not mean the affairs. They mean strictly profits shall be run by the board of directors. But when you come to our own CAMA does not even leave anything for affairs. So any place that you see business of the company, then you are supposed to interpret it to include affairs. Although I argued against this when I submitted that when reading the provisions of section 27, which are the things that are to be written in the memorandum, under section 27(1)(c), the object clause, it says that the business of the company, where it is profit oriented, but where the company limited by guarantee, then the object of the company. Now, they were very clear when they said the business there. If they had used the business in profit wise, then when you are interpreting this provision as well, business there should be interpreted profit wise, because if you look at the interpretation section, it was also profit wise. However, the argument might seem tenable, but when you look at the opposite of it, which means what then would then be regarded as the affairs of the company? How then do we lead ourselves through CAMA? Because there is no part of it that talks about affairs of the company. So any part you see would be business. So who then would then govern the affairs of the company? Do you understand what I'm saying? Now, when we then look at the case of Virgin Tech and Mohammed, and we also look at the case of Odutola Odis versus Lade Jobi, you would see that in both cases, the business of the company wasn't called into question. It was the affairs of the company that was called into question. The first one was where a director took money, siphoned money from company's account to a personal account. That has nothing to do with the business of the company, but that has everything to do with the affairs of the company. So they brought the matter to court. Although the issue before the court was whether or not the CEO can institute proceeding, the CEO was given the power to institute proceeding not on things that affect the profit of the company. If we are talking about things that affect the profit of the company, then we'll be talking about the company having business with another company. So there was a contract. So in this contract, something happened. Okay, the CEO, since it's within the business, as business, yes, profit oriented, CEO, oh yeah, move on. Do you understand? But this one, okay, somebody is siphoning money and we want to stop the person, want to seek an interim injunction to freeze the person's account. So, okay, let us go to court. Now, the substance of it is on the affairs of the company, that the affairs of the company is not run properly. So, we are going to court to rectify it. That has nothing to do with the business in the strict sense of interpreting business in line with section 868. Same as the case of Lade Jobi versus Odutola Holdings. You will see that there, director was removed, director was appointed. They are saying that the removal and the appointment, they were both void. Now, the question is, can the board of directors institute proceeding? Both removal and they are all affairs of the company. They have nothing to do with the business of the company when you are interpreting it stricto sensu to section 868. But you will see that in both cases, the court in both cases interpreted section 87 to not only include business in line with profit making, but to open it up to affairs. That's why I said I wanted you to take note of the fact that section 87 sub 3 in both cases were interpreted as the business of the company, especially Odutola versus Lade Jobi. Do you understand? So if you look at it very properly, although our karma could have been short-sighted by not encapsulating both business for profit and business for affairs, but only looking at it from the light of business for profit, while other jurisdictions like the Canadian and the Australian Act properly, defined their business and their affairs. The Australian said they are both the same. The Canadian said no, they are different. So when you are interpreting it, you know how to interpret it. But ours have to be interpreted with case laws. And I've given you 2 case laws for the purpose of such interpretation, and that will be the case of Lade Jobi versus Odutola Holdings and Virgin Tech versus Mohammed. It is on this that I then end my lecture on what the business of the company is and the interpretation of both cases. Now I'm going to a brand new aspect of teaching organs of government, which would be the liability for the act of the company, who will be held liable where something goes wrong in the company. And that is what I will start in my next lecture. See you there.